This is Jason Barber with Holistic Planning, coming to you today to talk to you about the differences between a living trust and a will and why you might consider one over the other. So first, we want to really talk about the big picture here and kind of drill down into the details after that. So ultimately, at the end of the day, both of these documents, a living trust and a will, they ultimately do the same thing. The end result is the same, okay? That is, I have a document that talks about some of the specific things that I want to have happen with my assets when I die. Okay, or in some cases while I'm alive, but maybe I'm incapacitated, et cetera. But the end result is both are documents that spell out this this basic information. So what's the difference, and why would I consider one over the other? And this is really a tough question, and I should state the obvious, which is that I'm not an attorney. I'm not an estate planning attorney, and this isn't legal advice, but this is just me providing education of what I do know about this. So I would say that this is probably something that is a state-by-state issue. There are certain states that have a relatively simple probate process, and there's some states where the probate process is extraordinarily expensive. So the difference, really high level, kind of skipped over this a little bit, I apologize, but the difference is that a living trust avoids the probate process or the court proceedings involved with probating somebody's estate. So a living trust, the advocates and the people that are pro-living trust typically will tell you that, well, it's going to be less expensive in the long run because you're not going to have to hire an attorney when you die. It's a lot faster of a process. It's a lot more private. It's a lot lower probability that there be any kind of somebody contesting your will. It's generally a like I said, a faster, more private, more secure, easier to handle process of probating your or distributing your assets rather. Now, depending on the assets that you have, how much assets you have, where they're located, what they are, that can affect how complex a probate proceeding could be. If you don't really have any kind of real estate assets, and if all you have is just money that's in a bank account, then you could put a beneficiary designation on a bank account, sometimes called a TOD, or on an investment account. Sometimes they'll also call it a POD, which stands for payable on death. You could put a beneficiary designation on an account, which also avoids the probate process. So it is possible that you could avoid probate without having a living trust. It isn't a guarantee, but I think that the more real property assets that you have, if you have property or real estate assets in multiple states, then a living trust does generally tend to become a really, really attractive vehicle because you want to avoid that probate process. One thing that's also really important to understand about a living trust is that there's a difference. You know, a lot of times when people hear that term trust, immediately their mind goes to, well, this is something that really, really rich people use to, or trust fund babies, et cetera. It's not exactly the same thing. A living trust is again the most simple version of a trust. It doesn't give you any kind of creditor protection, doesn't protect you from lawsuits. You have total control over all assets. As the trustee of the trust, you have total control over all of the assets that are in the trust. You can take assets out of the trust. You could terminate the trust. It's very easy, simple version of a trust. We'll probably cover this in another video, but there are what are called irrevocable trusts or testamentary trust and different flavors of trust that have more of a process of actually giving away assets and storing assets in a trust. And those, I would say, are a horse of a different color. They're more complex and generally more complex from a tax standpoint and harder to understand for the average person. But a living trust isn't any of those things. Tends to be a very, very simple document, and oftentimes, less expensive to operate than some other type of trust. So why would a person want to do a trust? Well, I'd say, like, at the end of the day, if you like the idea of not having to go through the probate process, if you've If you've been through a process before with a family member that passed away where you didn't like that experience for one reason or another, then I think you would be more inclined to prefer the living trust. I think if you have several real estate assets, I think that the trust becomes a very attractive opportunity. And I think that if you have a possibility or a higher probability of the public knowledge of your assets being of concern, then I'd say a trust becomes more attractive. Certainly if you have a higher probability of somebody wanting to contest what your will says, then again, the privacy aspect makes the trust more attractive. One of the negatives of living trust and the knocks on living trust is that oftentimes attorneys, or really anybody for that matter, will charge a higher fee to draft a trust document as compared to drafting a will. And oftentimes I'd like to think that higher fee typically is just associated with a little bit of extra work associated with deeding properties into that trust. This is a very important thing to understand, that let's say you have a home, or maybe you've got a home and some land, or some assets that have deeds associated with them. If you go and you create a trust and you say, okay, I've now got a living trust, but that home is still titled in your name and not in the name of the trust, then in essence, what you've got is quite literally a paperweight. If the trust is only going to apply to assets that are owned by or titled in the name of the trust. So this is a very, very important process in this whole thing, is actually funding the trust. Okay, so you need to make sure that those real estate assets are titled in the name and deeded into the trust. You need to make sure that if you have, say, an after-tax investment account, you may very well either want to move those assets into the name of the living trust, or you may very well want to just leave as beneficiary of that account. You can list the trust as beneficiary of the account, and that's also a possible solution as well. So I don't think that living trusts are right for everybody, but I do think that it is generally a nice thing to have. It's a luxury, maybe would be what I would say. And I think it's a nice thing for folks that have a little bit more complex estate. Typically, when you get one of these documents, when you get a will done, when you get a living trust done, oftentimes as a package, as kind of part of the whole process, you typically are going to also find that you'll get more documents. You'll oftentimes get a medical power of attorney and a financial power of attorney and a HIPAA release document, and potentially some other miscellaneous legal documents that will come as part of the overall package. And that's very, very important that those documents are updated. And for some people, I think it's actually safe to say that power of attorney documents can be the most important document that they have. For example, if you have someone, or if we had a client that maybe didn't really have a sizable amount of assets, or maybe it was a relatively simple estate that wasn't going to have to go through probate, there's not necessarily a huge need for having a will or a living trust in that circumstance. But then the question arises, okay, if you don't pass away, but rather you become incapacitated for one reason or another, what happens next? Who's going to be handling your financial business? Who's going to be handling your medical decisions? And that's where the importance of having those financial power of attorneys and medical power of attorneys really comes through. So what I, as a financial advisor for the last 12 years, what I have observed is that so many people that I talk to have not done anything in this arrangement. Many people have not done a will, they've not done a trust, they've not done power of attorneys. And I can understand why, because oftentimes it's like, well, I don't really want to do it myself. It's easy to procrastinate. It's oftentimes very expensive. Oftentimes if I want to have a professional do it, oftentimes I'm going to a professional's office that I've never met before, and I'm talking about subjects that are really, really uncomfortable and not fun to talk about, and it's just easier to just not do it, or to just kick the can down the road, say, I'll do that at a different time, when I'm older. That's something I'll do when I'm older. When the reality is that really, if you're over the age of 18 and or maybe you've got more than two nickels to rub together, it's really, really important that you have these documents, and not only that, but that you revisit them periodically, perhaps every 5 to 7 years. Even if nothing has changed, oftentimes it makes sense just from a good practice standpoint to refresh these documents every 5 to 7 years. So that's at least what we really encourage. Now, One of the things that is really, really cool and special about our new business, Holistic Planning, is, as our name suggests, we have the ability now, unlike in our previous world, we have the ability to actually help you get these documents created. So rather than, for let's just say for the 9 out of 10 of our clients that have relatively simple estate planning needs, maybe they, say for example, they don't have more than 10 or $20 million, and they don't really have a high probability of somebody contesting their estate plan. And maybe they just say, well, generally speaking, if I die, she gets it. If she dies, I get it. When we both die, our kids get it. And everything is pretty straightforward. Then really we have the ability, using some qualified attorneys that we outsource to be able to get these documents drafted for you by attorneys, not drafted by us, but legal documents drafted by attorneys specific to your state. And in our experience, based on kind of the averages that we've seen, it seems as though the price ends up coming in at, probably about half of what you would normally expect to pay. Now, in all fairness, I do think that this doesn't diminish the role for good legal advice from an attorney if you have a complex estate planning need. And we're more than happy to refer you to good qualified attorneys if you have a complex estate planning need. So that's not what this service is meant to take the place of. But again, for the 9 out of 10 people that don't have a complex estate planning need, that don't really feel comfortable going and talking about this to somebody new, this is really, really nice service that we now offer, that we can help you get this done at a significant discount to what you would normally expect to pay, and do it with people that you're already working with and that we're already helping you with your other business. And it just really works out very nicely that way. So we're so glad that we're able to offer this, and we really look forward to helping you. Give us a call at 936-800-0800 or set up a meeting at holisticplanning.com.